Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Good morning.
Morning.
Kiefer Brown.
Yep, give me just a second, Mr. Brown.
Okay.
Mr. Norman,
Good morning, Your Honor.
we are on the record. This is 2-1-169-485. Kiefer Brown versus Protector Window and Door. Your appearances.
Michael Norman on behalf of Protector,
Bar number.
P75844.
And you are Kiefer Brown?
Yes, I am.
All right, gentlemen, you guys had a case evaluation. Did that settle the case or not?
It did not, Your Honor.
But I did accept what the evaluator's conclusion, due to me catching COVID, due to me having death in the family, I didn't respond before the deadline.
All right, let's stop right here. Mr. Norman, did your client accept the case evaluation?
No, Your Honor.
Okay, so you don't have to settle case either way. Okay, so be it. What I'm going to suggest is that I'm going to give you guys another date, and I'm going to see if you can get you in the chat room, see if you can settle the file. I think that if I got a note from Mr. Brown, which I will not share, but I think that based on that, there's some possibility you guys could settle your file. If not, you can. Mr. Norman,
Yes, Your Honor.
are you in a position where in your car
You saw I'm in the Oakland County Courthouse.
you can go into a chat room? Can you do that from where you are?
Yes, Your Honor. I'm just in the parking lot of the Oakland County Courthouse.
Oh, okay. Then your next day, gentlemen, will be November 17th, at 10 o'clock. I'm going to send that to you in writing.
Thank you, Your Honor.
Now, hang on. Now, let me put you in the chat room, see if you guys can't work this out. If you
Thank
work
you.
it out, then send in the paperwork. If not, I'll see you November 17th.
Thank you.
Okay?
Thank you.
Now, let's get you in the chat room. We can get this case settled.
Thank you.
Rule 3, Michael Norman. Rule 3. Okay, gentlemen.
Good morning, Judge.
Mr. Perry, good morning.
Good morning, Your Honor.
Morning. We are on the record. This is file number 22-183670. Midland Credit Management versus Delilah Soto. Your appearances.
Andrew Perry, P69402 on behalf of plaintiff.
What is your name?
Your Honor, this is not my case.
I got the wrong person. I hit the wrong button. I'm sorry.
It's okay. I'm here in place of Allison Smith on the Hereford case. I'm covering for her today.
Okay, I'll put you back in the waiting room.
Okay,
I'll get Miss Soto out.
thank you.
I clicked on the wrong one here. Hello? We're connecting her up to the audio now.
Okay,
Didn't connect. I'm gonna put her back in the waiting room and try to take her out again, but she's not connecting the audio.
okay, Judge.
Let's try it one more time, then I'm gonna have to move on.
Will the hearing be reset to a new date or?
No. I'm just gonna move on my docket. Get a pair that works.
Okay,
This isn't happening. I'm gonna put you back in the waiting room.
all right, Judge, thank you.
Waste my time. Let's try it again, Ms. Amoon.
Okay,
You got 988.
yes.
All right. We are on the record calling file number 22-187988. The file is entitled Lativia Hereford, versus the Liberty Surplus Insurance. Date and time for pretrial. Your appearance.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Ms. Hereford.
Good morning, Your Honor. Fatima Hammoud on behalf of defendant Liberty Mutual P84217.
Where are we on this file, people? I mean, it's
I
not a
believe-
large claim, and we've got our 2.302A disclosures. So where are we on this file?
Your Honor, I believe Defense Counsel's office has been trying to get IMEs completed on this case. I also believe that they recently filed a motion to allow
Correct.
the deposition of Ms. Hereford's service provider. Plaintiff offers no objection to that motion. We're willing to stipulate to that deposition moving forward. We cannot agree to produce that service provider because service provider is not our client, but we're not opposed to that deposition going. So I think we need to complete the IME, complete this deposition, and hopefully we can get this wrapped up. I would point out that my client did show up to an IME and she was turned away at the doctor's office. She tried to submit to it. I really don't know what the problem was, other than this problem with not providing a copy of the driver's license, but I think we can get that sorted out, Your Honor.
All right, well, two questions. First of all, Ms. Hamud, why did you file a motion that Mr. Clardy is willing to agree to?
The motion was filed on 10/12. I'm not sure if Allison knew that he would agree to it or not, but the reason why the motion was filed was because there's a lot of outstanding questions as far as if she was expecting to be paid and things like that.
My question. Before you file a motion, the court rules require you to find out whether or not there's going to be opposition.
Correct.
And I want to know why that motion was filed without that being done.
Your Honor, I believe if Allison Smith filed it, she may have believed that there could be opposition.
And she's clairvoyant?
I'm sorry?
Is she clairvoyant?
I don't think so.
Then she should have asked. That's what the court rule requires.
Absolutely.
Your Honor, I would add that I believe Ms. Smith's office initially this is my understanding right now. They wanted to initially get plaintiff's deposition, and they instead filed the motion for the service provider. So I did tell Ms. Smith that we were not going to provide plaintiff's deposition voluntarily. But then I think they wanted to get the service provider step alternatively. So I just want to point that out in Ms. Hamud's defense, since she's standing in today, that perhaps there was a misunderstanding. But in any event, we're not going to oppose that motion. We're fine with just, letting you guys subpoena her.
All right, this is what's going to happen. Ms. Hamud is going to submit a stipulated order in regard to that agreed upon deposition. I'm going to give you guys another date, which will be November 17th at 11 o'clock. So let's get something accomplished on this file. And Ms. Hamud, you might talk to your cohort and remind her of the court rule requirement. The object of the exercise is not killing trees unnecessarily, keeping costs down. You pay $20 for a motion you didn't have to pay simply by picking up a telephone.
Okay.
Then we'll figure out what's going on with the IME issue. I don't understand the problem there, but Mr. Clardy seems to believe that can get worked out. So let's get it worked out. November 17th, guys, will be our next date at 10 o'clock.
Yeah, 10 o'clock or 11, Your Honor.
10 o'clock like today, ma'am.
Okay. Thank you.
Thank you, Your Honor.
All right, thank you both. Mr. Clardy, you got another one?
I do. I believe that is Mr. Oswald.
Mr. Oswald. I don't see Mr. Oswald here.
Oh, I'm sorry. And plaintiff's name is Oswald. Let me see what brother counsel or sister counsel
Boyke.
is. Yes.
I got Boyke here. So let's get in on that one. Mr. Boyke, good morning.
Good morning, Your Honor.
We're on the record. This is file number 22-187674. Richard Oswald versus Progressive Michigan Insurance. Appearances, please, gentlemen.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Mr. Oswald.
Charles Blakey, Your Honor, P77261, appearing on behalf of defendant Progressive.
Okay, we were last together on this file on September the 22nd. Have we taken the deposition of the plaintiff?
No, Your Honor, that's scheduled for November 7th, just coming up.
November 7th?
Yes, Your Honor.
Okay, then I will see you gentlemen again November 17th at 10 o'clock. Does that work for you, Mr. Boyke?
Yes, Your Honor.
I already know it works for Mr. Clardy because he has another one with me at that same date and time. So you guys will get the dep done on the 7th, and I'll see you 10 days later, November 17th at 10 o'clock. Is there anything else we can accomplish today?
No, I do want to tell Mr. Boyke while we're here, I got your email with Mr. Boyke's office has made an offer to settle the case. Right now we are considering it. I'm just trying to figure out what the liens are on this case. These lien holders sometimes like to take their sweet time getting stuff back. So I just wanted him to know that we are working on it. I'm not ignoring his email, and we'll try to get this resolved.
Yeah, and we could probably carve out that medical, Connor. So I just didn't have your cell phone, so I gave you a call back at your office, but probably got lost in the voicemails and stuff. So if you
Okay.
text me a cell or something, I'll give you a ring.
Okay, that sounds good. Yeah, here, I'll shoot my.
No. I'll put you guys in the chat room. You can do that. Unless
Okay.
you want to give your cell phone to everybody in the world.
Okay,
Yeah.
thank you. That's
I
probably a good
appreciate
idea.
that.
November 17th at 10 o'clock, okay?
All right,
See you
thank
then.
you, Your Honor.
I'm gonna put you guys into a chat room so you can exchange that other private information.
Thank you, Your Honor.
Thank you, Your
Have a
Honor.
good
Be
day.
safe.
You too.
You too.
Mr. Jansen? Good morning.
Good morning, Your Honor.
What file are you here on?
So, Your Honor, I was retained late yesterday by Miss Delia Soto, case number 221.
Okay. I have Mr. Perry here. I have Miss Soto, but she is not, she doesn't come in when we bring her in. But what I'll do is I'll get Mr. Perry and Miss Soto and we'll move forward.
Sure, thank you.
Have you filed an appearance?
No, I was trying to contact the court yesterday to find out where I could email that to.
Check our website, counsel. That's why we have it.
Okay, thank you, Judge.
All right, we're gonna try this one again. This is file number 22-183-670, Midland Credit Management versus Delia Soto. Could I have your appearances?
Good morning, Judge Andrew Perry, P69402 on behalf of plaintiff.
Counsel?
Good morning, Your Honor. Brandon Jansen, P78132 on behalf of the defendant.
All right, Ms. Soto is here, but she's not linking up audible, but it's not important because you're appearing on her behalf. Is that correct, counsel?
That is correct, Your Honor.
All right, so you file your appearance. And give me again, counsel, your, whoops, where I put it? Give me again your bar number.
78 78-132.
78132.
Correct, Your Honor.
All right, that'll do it. So where are we on this file, people? I believe counsel was saying he just got retained here.
Yeah,
Yeah.
so
Sorry, go ahead.
in this case, Judge, the prior attorney just withdrew. We
Right.
never received discovery responses to our discovery request that we sent. And we recently filed a motion for summary disposition that was mailed to the consumer on October 5th. So when I get the appearance from the new attorney, I can send him a copy of the motion that we filed.
All
So,
right.
I am in receipt. So Ms. Soto did bring me the motion for summary and the attachments there. And I believe it looks like there was a request for admissions that were filed and never answered by prior counsel. I believe in this case, like I said, I just got the documents yesterday afternoon, but I believe I'll be filing a notice of third party at fault. In this case, Ms. Soto hired a debt consolidation company, which I believe hired her initial attorney on this case, who appeared and then withdrew. And looking over that, it looked like that company, Pure Solutions, agreed by a contract that they were going to take care of this debt with Midland Credit Management, which I believe started out with Chase Bank.
Okay, well, I'll deal with that motion if and when it comes in.
Mm-hmm.
And what I'm going to do now is I'm going to adjourn this matter to November 17th at 10 o'clock. And counsel, I look forward to your appearance and we'll see where we're going from there.
All right, Judge, November 17th at 10 a.m.
Correct.
All right, so it's an adjourned hearing.
It's going to adjourn pretrial date and give counsel an opportunity to get his feet on the ground and see where
Yeah.
we are on this file.
All right, thank you so much.
All right, thank you, gentlemen. Thank you, ma'am. November 17th, we'll talk to you then. Make sure you get that appearance in, counsel.
I'm doing it right now. Thank you, Judge. Have a good
Thank
day.
you. You too, sir.
Thank you.
Pardon me, Judge.
Yes.
I have an 11 o'clock case with you today. Should I sign off or should I stay logged on?
It's up to you. You want me to put you in the waiting room
That's fine.
or you want to come back?
I can go to the waiting room. That's on Midland versus Jason White. So if
Okay.
he early, I guess I'll be ready.
All right. Waiting room you go.
Thank you.
Counsel, get that appearance in.
Thank you, Judge.
Yes, sir. Hello? Hello?
Good morning, Honorable Judge Robinson,
What is your name?
Teresa J. Moss.
Okay. I don't have Ms. Mason as of yet. So I'll put you back in the waiting room. I'll just mute you for now because I don't have Ms. Mason as of yet.
Yes, sir. Okay, thank you.
Okay, I'll just put you on mute.
Thank
Put
you.
you back in the waiting room. I don't know if things gonna work.
Okay, sir. Morning.
All right.
Yes.
We are on the record calling file number 22179-699, Modern Financial Services versus Teresa Moss. By a notice dated September 15th, 2022. This matter is set for hearing today, October 20th at 10 o'clock on the plaintiff's motion for summary disposition. It's now after 10:30. Could I have your appearance, please? Tell me your name, ma'am.
Teresa J. Moss.
Ms. Moss, did you file an answer to this motion for summary disposition?
Yes, I did.
Okay, it is not in my file, but I looked at the register of action and it says that it was in fact filed. So what I'm going to have to do is I'm going to simply at this point dismiss this matter because the plaintiff has failed to appear. If she reprecipices it, then we will already have your answer to the motion in the file, and then we can reschedule the motion for summary disposition. But as of today, plaintiff having failed to appear, no good cause of that failure having been shown, plaintiff's motion for summary disposition is dismissed. We'll send you out an order on that today, ma'am. Thank you for coming in. Have a good day.
Thank you, sir. Thank you. I'm just nervous. I just wanted to tell the truth on everything.
Okay, ma'am. Thank you.
Okay.
Have a good day.
You too.
Yes, ma'am.
You too, Honorable Judge Brothers.
And he's out of town. And all of these. 866-909-975. CJFN.org. Mary from Birmingham. And a big good morning here, Jay, Alan Harper, Joan of Detroit, Catherine in here, Christopher. In this. Surveillance. picks up the alias, the finale from the symphony number 2 in D major. Music is an art. It's fundamentally about feeling. And these performers are in the business of articulating feeling on the absolutely highest level of human experience. You can't make it a perfect circle if you don't have an audience receiving the feeling and giving it back to you. I'm Violinist James Ennis. Let's all make great music together. Please complete the circle by making a contribution to the public radio station. Thank you, James. That's us. The WRCJ in Detroit 86690. James Ennis here. Playing with the Detroit Symphony Orchestra. Yes, like that. Yes, yeah. Played the Mendelssohn Concerto. Fabulous music. Oh man. Rules. Yeah, yeah. So just so great. And you know, I'm so grateful for our listener support as we can bring everyone the Detroit Symphony Orchestra in these live broadcasts through our partnership. You know, and it's only possible by people who are listening like that and support us as a local group. And we can produce these programs in Michigan Philharmonic, the Symphony Orchestra, and Detroit Opera. We can bring you all these events and also share tickets with you, which I get such a great enjoyment out of. That people are so excited. Like they got almost excited. I know we get away and people say, "You're kidding! I won!" Yeah, I never won. Yeah, it's really good now. So thank you for calling in for tickets. Thank you for calling in and listening to our special broadcast. You call us right now. Your tax deductible contribution at 866-909-9725. Penny, thank you for your nice note. And Peter, Penny is a first time. She wrote us out. This station really represents the Michigan community. And also other folks we knew their membership this month. In Birmingham, Terry, in St. Shores, Michigan. At 866-909-9725. It's Oktoberfest. We're listening to music by the big guy who's showcasing the young Tibet democracy. Our fall membership campaign, Oktoberfest. And we're part of the nights. But you know it's going to be music all the time. Support it. Something really special for this one. Just about everyone.
Yeah. Oh, hold on one second. I'm about to go on the record with Judge Robinson. Let me call you back.
Oh, yeah, sure.
All right, thanks.
Yep, bye.
All right, good morning, gentlemen.
Good morning, Judge.
We are on the record. This is file number 22182-377. Midland Credit Management versus Jason White. This appears to be our initial pretrial. Your appearances.
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
And what is your name, sir?
My name is Jason White. Good morning, Your Honor.
Good morning. Is it your intention to represent yourself in this matter?
Yes, sir.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Perry will bind you. Do you understand that?
Yes, sir.
All right. You filed an answer to a complaint, and then you filed an amended answer. Did you have agreement with Mr. Perry to do that?
I did not have an agreement to do it. I filed it, and then I went back and looked at some things and then I sent it over.
Well, here's the problem, sir. Once you file your answer, if you want to amend your pleadings, you have a right to do that. But you have to seek leave of the court or stipulation of the other party. Let me get the court rule out for you.
Okay.
Two point one. Yeah, once you file your answer, then you have a right to file an answer. But then after that, you amend your pleadings only by two ways. Either by order of the court or by stipulation of the parties. So if you want to have your amended answer considered, you're going to have to either file a motion with the court or get a response from Mr. Perry. You filed your answer in this matter on September 22nd. And you had only 14 days from that day to file the second answer. Let me make sure you, I think you missed the date. Let me check it for you.
Okay.
September 22nd. 14 days is 1, 2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Yeah, it had to be filed by October the 6th under Michigan Court Rule 2.118, and it wasn't filed here until October the 8th. So right now, I will put in the file your amended answer, but it's not in any force in effect unless you get an order from the court or stipulation from Mr. Perry. Likewise, you also filed a motion to strike affidavit of debt. Is that correct?
Yes, Your Honor.
Did you pay the motion fee for that?
I did.
Okay, because I don't see that as either. Did you serve Mr. Perry with a copy of either your amended answer or your motion to strike affidavit of debt?
Yes, Your Honor, I did. It was received October 14th and was signed for by Sam.
Okay, what did you serve? Both of those things?
I served both copies of
Okay.
what I filed with the court.
Well, then make sure that the court has a copy of that proof of service.
Okay.
Have you received, Mr. Perry, that amended answer to complaint and motion to strike affidavit of debt?
Yes, Judge, we received both the amended or proposed amended answer and his motion.
All right, do you have any objection to his amended answer?
I have no objection.
All right, then what I'll do then is I will just enter an order permitting the tardy filing of the amended answer, plaintiff having had no objection to that. So where are we on this file, gentlemen?
Well, I thought originally, Judge, that the parties reached an agreement. I see the initial performance of the agreement with the payment being made, but then he filed the amended answer, then the motion. So I'm not sure if the file's still resolved or what's going on.
Okay, well, let me do this. Let me put you guys into a chat room and then you come back to me after you've had your conversation.
Okay, Judge.
Either you settle the case or you haven't. You know, it's kind of hard to have a half settled case. Let me put you guys in the chat room here.
Thank you.
Thank you.
Jason White. 4. Jason White. 4. Okay. .505, I have Muller and Harrell. Okay. So I can do them. Admit Muller, admit Harrell, 505. Good morning.
Good morning.
Morning, Counsel. I don't, Ms. Harrell, I don't have any sound from you apparently.
Sound, Your Honor. John, can you?
I just heard your voice.
John?
I heard your voice. Turn up your volume or get closer to your microphone. Can you hear me, Ms. Harrell?
Yes, I can hear you.
Now you're better. Let's call your file.
Is that better? I'm sorry, Your
Yes.
Honor.
This is file number 22-193-505. Dubois Chemicals versus the Detroit Bus Company. This appears to be our first pretrial. Could I have your respective appearances?
Yes, good morning, Your Honor. John Mueller appearing on behalf of the plaintiff.
Member of the State Bar of Michigan, Mr. Mueller.
Oh, yes, so my number, I'm sorry, it was up there, but I have P35413.
Counsel.
Good morning, Your Honor. Michelle Harrell, P48768, counsel for defendant Detroit Bus Company.
Okay. The court opened your written discovery on this matter on September 27th. What is this dispute about, Mr. Mueller?
My client shipped, it looks like a fairly large quantity of hand sanitizer to the defendant, and they're seeking payment.
And what is your claim dollar-wise? You still within my jurisdiction?
Yes, it's $7,646.
And Ms. Harrell, what's going on here?
Yes, Your Honor. So during the COVID pandemic, his client shipped some sort of chemical product to our business. Everyone was looking for hand sanitizer at the time, but they shipped this product. It was not ordered. There's no contract for it. When it was received, it's, as with a lot of sanitizer companies, this product was not usable. The company still has it because it has a terrible smell. And there were a lot of companies that got into the sanitizer business that really shouldn't have been. And so we tried to return these chemicals, but they, of course, didn't respond to us. And then they sent us an invoice. So there's no contract.
When were the chemicals shipped to your guys?
I believe they were shipped in maybe June of 2020.
June of 2020?
Yes,
And you still have the product now?
yes,
And it's October of 22?
yes, Your Honor. It's,
Okay.
you can't dispose of it because it's got alcohol and other chemical products in it. And so honestly, the client Detroit Bus doesn't know what to do with it, but the plaintiff would not take it back.
Mr. Mueller, you have a contract for this, or you shipped it out of your goodness of your heart? What's going on here?
All I show on my client's invoice was a verbal, they had a purchase number and it just shows verbal. So there's no written contract. They're claiming it was just a verbal request to purchase.
Okay, well, here's what I'm going to do. I'm going to give you guys another date, and you need to get started on your written discovery. We'll see you November 17th at 11 o'clock. Does that work for everybody?
Yes, Your Honor. Thank you.
Mr. Euclid?
I think that'll be fine.
Yeah.
Yes, Your Honor, that's fine. Thank you.
Okay, we'll continue your written discovery. Is there anything else we can accomplish today?
Not from what I just heard, I guess not. I've already started discovery, so I guess we'll just go down that route.
Okay. You guys want me to put you in a chat room so you can talk outside my presence?
Well, I wouldn't object. So
Okay.
why don't we?
Here's then.
Thank
I'm gonna put you in the chat room. I'll see you
Thank you.
November 17th at 11 o'clock, and let's get started on our written discovery, okay?
Okay.
Thank you, Judge.
Anything else we can accomplish today?
Nothing from plaintiff.
Anything for you, Ms. Harrell?
Nothing, Your Honor. Thank
All
you.
right. Let's get you on in the chat room. You guys get it worked out.
Thank
Thank
you.
you.
Okay, we're gonna go with Mr. Mueller with my room 2. Ms. Harrell, room 2. Okay.
Good morning, Judge.
Morning, counsel. We are on the record. This is file 20-165-999. Your respective appearance, New Horizon Chiropractic versus City of Detroit. Appearances.
Daniel Groves on behalf of the plaintiff, New Horizon Chiropractic.
Bar
Good morning,
number.
Judge. Good morning, Judge. John Cahalan, P77404 on behalf of defendant.
Mr. Groves, you remember the State Bar of Michigan, are you?
I think they just sent me a brand new card. You know, it's a blue. It used to be the same color for 10 years in a row. Now it's all blue. It's a brand new one, but it says 74026 on it.
All right. So where are we on this file, gentlemen? We were last together on September 22nd, and the defendant was trying to decide what was going to go on in regard to the order for partial summary disposition from August 6th. What decision did you make?
Brother counsel did discuss with myself. We've come to resolution and we've actually settled this matter. So we're requesting 30 days to execute the documents, have the release executed, the check sent, 30 days to submit the enter of dismissal with this court.
All right, counsel, you guys resolve your problem?
That's correct.
Okay. November 17th at 11 o'clock will be your next pretrial. Hopefully I don't have to see you by then. You should have your paperwork done by that time, just so you can just send in your stipend order dismissal.
Understood, Judge. One quick thing is that, I do have to get, it's a City of Detroit matter, so I do have to get City Council approval. Not that I think that's be an issue, but sometimes there can be a little bit of a delay on that. I'm going to do my best to make sure that gets in, but so we may not in 30 days have that. I'm going to do my best to make that happen, but some of it's out of my control with the City Council. So
well, I'll see you guys, or I'll not see you on that date.
Okay. All right. Just want to make the court aware of that.
Mr. Callahan, because we're coming up on holiday season. When do they adjourn?
Not till after that date,
Okay.
Judge. So you should be able to get it in. All right.
All right, guys. November 17th at 11 o'clock. Hopefully I won't have to see you again.
Okay. Thank you, Judge.
Bye-bye. Let's be safe out there. All right, give me just a second, gentlemen, to catch up, and I'll be with you just momentarily.
All right, Judge. Thank you.
No problem. Thank you.
All right, gentlemen, we are back on the record. This is file number 22-182377. The file is entitled Million Credit Management versus Jason White. Where are we, gentlemen?
We were able to reach an agreement, Judge. We have a resolution.
Okay, tell me the terms of that resolution.
We've agreed to the entry of a consent judgment for $10,893.79. We do acknowledge the $50 payment Mr. White made last month. Judge, we've agreed that Mr. White's going to pay this back in installments. We agreed to a $50 a month payment plan for 12 months, and we agreed to review that payment plan in 12 months to go back over his finances.
Okay.
And if we can't resolve it between the parties, I advise Mr. White that I may file a motion for the court to hear the issue.
Mr. White, did you hear those terms?
Yes, Your Honor.
Do you agree to those terms?
I do.
Okay. So what I'll do then, gentlemen, since I won't have to deal with the question of the amended answer or the motion. I'll simply dismiss your matter without prejudice. Looking forward to your conditional dismissal coming in with your installment payment terms. Is there anything else we can accomplish today?
Well, Judge, just to clarify, the agreement wasn't for the entry of a conditional dismissal, but a consent judgment.
Oh, excuse me, consent judgment. That was my error. Excuse me.
Oh, okay.
I'll look forward to the consent judgment then.
Judge, do I have permission to file that proposed consent judgment under the 7-day rule?
Well, you need to have Mr. White's signature. That's the problem.
Okay, I can mail it to Mr. White.
Okay? Anything
All right.
else, guys?
No, Judge, I think we're set. Thank you.
All right, let's be safe, y'all. Thanks for
Thank you,
coming.
you as well.
We're off the record.
Thank you, Judge.